Inquiry hearing is in session. Welcome to all members physically here, members in the virtual platform. Let me also welcome the public protector with us here and her legal team led by Advocate Mpofu. And welcome the evidence leaders, Advocate Bauer, as well as Advocate Mayosi. Welcome the public interacting with us and the media, the entire support staff. But let me also do a special welcome and acknowledge we have visitors and guests today outside of South Africa. So there seems to be an interest about this process. Allow me to introduce our guest from the African Ombuds and Office. I have with us the president of AOMA, who hails from Kenya, but also heads the Ombuds. That's Ms. Florence Kajuju. You're welcome to South Africa as well as this hearing. She's not alone, accompanied by Ms. Sokani from Zambia, as well as the support staff that's sitting behind here, Daisy Kazji. I hope I'm pronouncing that correctly. And Hilda Ojambo, as well as Bailua Chipasa. We had many Bailuas playing in South Africa, so it will not be difficult to pronounce that. You're all welcome to join us as we continue our work of an important process in our country and a pioneering process in that regard. It's a constitutional obligation to all members of the National Assembly as part of their oversight role. So thank you very much for your presence. I just want to indicate, to check first, if members in the virtual can hear us. Can I invite you, Honorable Begingosi, to talk to us? Begingosi?
Yes, Honorable Chair, I'm here.
You're here. Thank you. You're all welcome. I want us to immediately start, but before I recognize Advocate Bauer and Advocate Mayosi, I will quickly recognize Advocate Mpofu. Just a few issues he wants to put on the table for our records. Advocate Mpofu, you are recognized.
Thank you very much. Good morning, Honorable Chair, Honorable members, our special guests, Public Protector, and everyone present. Yes, thank you very much, Chair, for the opportunity. Firstly, let me just correct you. The president of IOMA is Advocate Mkhwebane, and this is the Secretary General. But that's fine.
I knew you would correct me.
Thank you, Chairperson. Now, no, Chair, I just wanted to, these are really just few housekeeping matters which I just wanted to place on the record. I'm not going to dwell much on them. Just because some of these documents we will upload, others are already in the possession of the members, but then their relevance might come at a later stage. For now, it's merely just to place them on the record. Maybe I should start firstly, excuse me, by thanking you, Honorable Chair, and the members for having given us the opportunity to go to court yesterday and today, rather Monday and Tuesday, even though you refused to give us today as a day for further preparation. But maybe that would be the first matter to say that the case was finalized and judgment was reserved. I'm sure everyone has seen that. And insofar as it might have any implications for this process, we will keep you updated if and when that happens. The second issue, Chair, which I wanted to place on the record is that on the 18th of July, 2022, we wrote a letter to the committee and to you via the chair, tabling various issues, again, which may crop up as we proceed. And we were happy to receive your response dated 22 July to that letter. Some of the matters, according to your response, are being referred for legal opinions and all that. So we will await the outcome of those if there's still anything outstanding. But again, which is just to place the matter on the record. I won't dwell much on that because I'm sure the members have seen that correspondence both ways. The last issue we want to place on the record is an issue that we had mentioned here, namely that on the 19th of July, which was the following day after your letter, we wrote a letter to the president, the letter that is envisaged in Directive 5.9 for him to voluntarily come and testify, and we outlined the reasons in that letter. We will send it to the evidence leaders, but in any event, it will come to you in due course when we take the next step. But the important thing is to report that we received a response to that letter, which on Monday, which was the deadline, and the president has declined our invitation to come and testify voluntarily. And as I say, that correspondence will form part of what we will forward to you as the next steps towards ensuring his attendance. Thank you, Chair.
Thank you. I guess you meant to say Directive 5.3.
Yes, 5.3. 5.3. So 5.9 was the one that was in your letter. Yes.
Yeah. No, thank you.
Okay,
thank
so
you.
now you've corrected me as well.
No, it's you would expect I do that.
Thank you.
Thank you very much, Advocate both. Thank you for placing those matters. We'll find a way to respond to them at some point, not now. I'm now going to take this opportunity to recognize Advocate Bauer and Advocate Mayosi.
Good morning. The plan of action for this morning is that our witness that we have is predominantly going to speak in relation to the Vrede matter. Before we swear the witness in, Advocate Mayosi will give you a background, as we have done on the occasions when we've introduced the witness on a different issue in the motion and the judgment in relation thereto. And thereafter, the witness will be sworn in and I will lead him through direct evidence.
Thank you, Advocate Bauer. Before I go to Advocate Mayosi, Honorable Heron.
Thank you, Chair. Just before we get into the evidence, I see that the directives were not amended, which means that Directive 5.9 still stands. And as you may recall, we had questions arising out of Mr. Kakana's evidence that we wanted to pose to the public protector. Now, we didn't pose those questions because we were going to debate whether 5.9 should be amended. So can you just give some direction as to when those questions can be posed to the public protector?
I will respond that during the course of the day. Thank you. I now recognize Advocate Mayosi.
Thank you, Chair. Good morning, honorable members, the Public Protector, Mr. Mpofu, and the guests that are here. Mine this morning is merely to give some introductory remarks in relation to the Circulated Dairy project and the reasons why there is a complaint against the Public Protector arising from that matter. As members will be aware, the Circulated Dairy project complaint against it emanated from 3 complaints that were placed by Mr. Jenkelson. He first complained with the PPSA on the 12th of September in 2013. He lodged another complaint in March 2014, and he complained again in May 2016. Prior to that, National Treasury had itself investigated the Circulated Integrated Dairy Project. In June 2013, National Treasury's procurement officer had requested National Treasury to investigate allegations of procurement irregularities allegedly committed by the Free State Department of Agriculture and Rural Development. ENS Forensics was then commissioned to assist National Treasury with this investigation. Some procurement irregularities were indeed found, and certain disciplinary actions were recommended by ENS Forensics arising from their investigation. During the course of the investigation by the PPSA, a provisional report dated November 2014 appears to have been issued. It's unsigned. It is in the name of the former public protector, Advocate Madonsela. The status of this report and who exactly it should be attributed to is a matter which the next witness is going to testify about. The PP finally issued a report in relation to this investigation in February 2018. This report is the report number 31 of 2017-18. In her findings, she found that there were, in fact, procurement irregularities, and there was a failure to comply with National Treasury prescripts. In her remedial action, the PP required the Premier of the Free State to initiate and institute disciplinary proceedings against all implicated officials in the Circulated Dairy Farm project. On the 20th of February 2018, the DA launched court proceedings seeking various forms of relief, including a declarator that the PP had acted unlawfully and in violation of a constitutional mandate. The DA also sought the review and the setting aside of report number 31 of 2017-18. Later that same month, KSAC also launched proceedings seeking the review and setting aside of the report. The applications were based on the same facts, and they were heard simultaneously. Judgment was handed down on the 20th of May 2019 by Tolmay J. The court declared that in conducting her investigation and reporting on the Circulated Dairy project for the purposes of her report, the PP had failed in her duties under Sections 6 and 7 of the PP Act and Section 182 of the Constitution. The report number 31 of 2017-18 was then set aside and declared to be unlawful, unconstitutional, and invalid. The court reserved judgment on costs. This judgment was reserved pending the Constitutional Court judgment in the PP versus Saab matter, which dealt inter alia with an award of a punitive costs order by the High Court in that matter against the PP in her official and in her personal capacity. The Constitutional Court handed down judgment in July 2019, July 2019, and after that, the High Court then handed down its judgment on costs on the 15th of August 2019. The PP was then ordered to pay 92.5% in her official capacity of the costs of the DA on an attorney and client scale, including the costs of true counsel. A similar costs order was made in her official capacity that she pay 92.5% of the costs of KSAC, also on an attorney and client scale. And in her personal capacity, she was ordered to pay 7.5% of the costs of the DA on an attorney and client scale. And similarly, in her personal capacity, she was ordered to pay 7.5% of the costs of KSAC on an attorney and client scale. The PP applied for leave to appeal, appealing both the judgment on the merits and the judgment on costs. The hearing before Tolmay J happened on the 11th of December 2019, and he gave judgment on the 13th of December 2019. In his judgment, thanks, Mr. Bofo. In her judgment, she dismissed the applications for leave to appeal against both the judgment on the merits and the judgment on the costs. The complaint against Advocate Mkhwebane in relation to the Vrede Dairy project are concerned both with the manner in which she allegedly conducted the investigation and also the manner in which she allegedly conducted herself during the litigation. In this regard, as members will be aware, she is allegedly, she's said to be guilty of misconduct. As members will be aware, that those are the specific charges that are placed there on the monitor. She narrowed the scope of the investigation, 4.1 and 4.2, she failed to investigate at all. The third complaint by Mr. Jankelson. And then it goes on to say that the steps taken by her in the conduct of the investigation were wholly inadequate, considering the magnitude and importance of the complaints. And of course, it is then said in 4.5, 4.4, she materially altered the remedial action proposed in the provisional report prepared by her predecessor. And then in 4.5, it is said that in statements that she made under oath in the litigation, her statements were contradictory. Her explanations were contradictory. Her affidavits in that litigation are found in bound A, page, her affidavit in the DA matter is on page 1581 to 1658, and her answering affidavit in the KSAC matter, bundle A, page 1829 to 1870. And so I will then hand over to Advocate Bauer to take this witness through, having provided that brief background as to the context of this witness. Thank you.
Thank you, Advocate Mayosi. I recognize Advocate Bauer.
Mr. Chairperson, the witness that we are calling this morning is Mr. Sphelo Hamilton Samuel.
Thank you. Thank you, Advocate Bauer. I'm going to ask Ms. Fatima Ibrahim to interact with Mr. Sphelo Samuel. Ms. Fatima Ibrahim.
Thank you, Chair. Good morning, Mr. Samuel. Could I please ask you to state your full name for the record?
Sphelo Hamilton Samuel.
Thank you. Mr. Samuel, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law, you are required to answer fully and satisfactorily all questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers Act, A person who willfully furnishes a house or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. So you will now be required to take either an oath or to affirm that the evidence you are about to give is truthful. You may choose either the oath or affirmation. Which do you prefer?
Yeah, I prefer to take the oath.
May I ask that you please raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the
So
truth.
help me God.
So help me God.
Chairperson, the witness is now duly sworn in. Thank you.
Thank you, Ms. Ibrahim, and thank you, Mr. Samuel. I now recognize Advocate Bauer.
Good morning, Mr. Samuel. You provided the evidence leaders with an affidavit, and you have a copy of that affidavit before you, correct?
That is correct, Chair.
There is also a previous affidavit which was provided, which you had provided to the Speaker of the National Assembly on 11th February 2020.
That is
What was
correct.
deposed on that date. Right. Now, just so that those who are following virtually, the affidavits are in bundle D. The first one, to which I'm going to spend a considerable amount of time with, is located at page 2069. It's item 8. The second affidavit is located at page 2747. Mr. Samuel, you are an attorney of the High Court of South Africa, correct?
That is correct, Chair.
And you were so admitted in April 1995.
Correct, Chair.
You hold a BProc degree from the University of KZN, then University of Natal, and you've practiced law and worked briefly as the executive officer of the Law Society of the Free State.
That is correct, Chair.
Now, you joined the Office of the Public Protector on 1 December 2000.
That is correct.
You joined in the capacity as a senior investigator. You held that position for 9 years, and thereafter you were appointed as the provincial representative of the Public Protector in Limpopo.
That is correct.
Right? And you stayed there until 2015, whereafter you were transferred at your request to the Free State Provincial Office as provincial representative.
That is correct.
And you held that position for some 20 years prior to your dismissal, which we will deal with in greater detail later, correct?
That specific position I've held for 11 years, but in total I've been in the employ of the Public Protector SA for 20 years.
And not to leave that hanging, subsequent to that, you've been reinstated.
That is correct.
And we'll deal with those details as we go on. So you are one of those persons at the Office of the Public Protector that had served under all the public protectors.
That is correct, Chair.
Mr. Samuel, I want to deal in the first instance with the matter which Advocate Mayosi had dealt with, and that's the Vrede Dairy matter, which starts in your affidavit at page 2116 from paragraph 30 onwards.
Paragraph 130, yes, that's correct.
Now, this was an investigation that had commenced during the term of Advocate Madansala. Correct?
That is correct, Chair.
And it had not yet been completed when the investigation had not yet been completed.
That is so.
by the time she had vacated the office.
That is correct.
Right? The report which Advocate Mayosi had referred to was a report that had actually been published by Advocate Kabani in February 2018, correct?
That is correct.
Right. Now, when did you first have any involvement in the Freda investigation? You transferred to the Free State office in 2015.
In the investigation, I became involved when I transferred to the Free State Provincial Office in 2015. But prior to that, I had sat in what we called the think tank, where this report was presented during Advocate Madonsela's time. And so I knew about this investigation then.
So a report had been presented to the think tank during Advocate Madonsela's term.
That is correct.
Right. And by virtue of your transfer to the Free State, did it now fall under your supervision of the investigation?
That is correct.
And who was the assigned investigators?
The assigned investigator was Advocate Celia. She was assisted by some investigators in the office.
Right. Sorry, Mr. Chair, could we just ask the IT people to make sure that the affidavit comes onto the screen, please?
Okay, IT, you got that? Applied the presentation. Thank you.
So you indicate in paragraph 132 that at the time you had taken office in 2015, there was a draft of the Freda report dated November 2014, which had been prepared by Advocate Cilius.
That is correct, Chair.
And what happened to the draft thereafter?
The draft was referred back for further investigation because Advocate Madonsela was not happy with the fact that it was not wide enough to include the role of politicians in the matter.
And how did you come to know that Advocate Madonsela was not happy about that?
First, it was in the think tank before I transferred to the Free State. And then when I was in the Free State, she spoke to me to take charge of the investigation and explore the role of politicians.
Okay. So in paragraph 133, you say that a further draft was prepared in 2016. And what transpired with that draft?
Yes, that is correct. Advocate Madonsela was still not happy with that draft. And she again sent it back and said, requested that, as I said, that I take charge of the report and expedite and make sure that it covers sufficiently the role of politicians.
Okay. Now, Mr. Samuels, you referred to a draft prepared in 2016. And if we turn to page 2200 which is SS6. Right. Can you identify this email that you see at 2,200?
Yes, Chair, this was an email sent by Advocate Celia to me and copied to other members of the Free State office, which was attached a number of reports for the think tank, and amongst those reports was the Friede Dairy report.
And if you go to the next page, is this an extract of the report that was attached to the email?
Yes, that is correct.
And if you turn to page 2000, well, actually you can stay on the page where we are, 2203, in the top heading, the date still says November 2014. Can you explain that, Mr. Samuel?
This report was the initial report. I mean, the reference to November 2014 was the reference to the very first report that was submitted to the think tank. But, further drafts will still reflect that date of November 2014. They were not quite updated to reflect the period when they were revised and sent through.
Okay. And if you go to paragraph 2217. Page 2217, sorry. If you go down, further down on the page, right, you will see whose name is signed at the end of, is typed in at the end of that report.
It reflects the name of the public protector, Advocate Enquiry.
And it says she's assisted by the Free State Provincial Office.
That is correct.
Right. And so if we take you, and why was that at the time as such, Mr. Samuel?
Excuse me, could you repeat the question, please?
Why, how come her name was at the end of the report?
It was on this report because she had already been appointed as the public protector.
Okay. So when Ms. Celia sends this email off on the 14th of November 2016 with the draft report attached, Advocate Mkabani's name is at the end of the report.
That is correct.
And then if you go back to page 2117 of your affidavit, you say that paragraph 134.3, you say that this is the report This is the same report that was filed in the court proceedings as the provisional report,
That is correct.
right? Except, and what difference is there between this report and the report that is annexed to Advocate Cilliers' email?
The difference is that it was the same report as the 2014 draft, but the one that was used in the proceedings reflected, and that was filed by Advocate Mkhwane, reflected Advocate Madonsela at the end of the document.
And had there been changes made to this report since Advocate Madonsela had left office?
No,
And had Advocate Madonsela signed off on any provincial report?
no, she had not.
And did this draft address Advocate Madonsela's concerns?
No, it did not.
And why not, Mr. Samuel?
There was a further investigation still underway, specifically to address Advocate Madonsela's concerns, which, as I have said, were specifically to look at the role of the politicians in the whole Circulated dairy matter.
Okay. Can we just ask the IT people to put the affidavit back on the screen, please?
IT, are you winning? Comes from? From Zoom. Yeah, I'm referring to them there. Thank you. Just a little bit of patience. Is that the one you're looking for, Advocate Bauer? Your mic, please.
Yes, thank you, Chair.
Thank you.
So you had the 2014 report now in 2016, and then what did you do after that, Mr. Samuel?
The investigation was still ongoing, but what I then did was to inquire whether Section 79 letters had been sent to Head Office Quality Assurance Unit. This was at the request of the Public Protector, that those Section 79 letters be sent with a draft report as Advocate Matlawe, who was doing quality assurance of reports at the time, indicated to me.
Okay. And so Advocate Cilliers sent you the draft, and if you look at page 2218, This is the email requesting the draft. And if you look at the bottom of 2218, go down further. Advocate Celia says at the bottom, these were the ones sent after the TT approved the report. What does that mean?
It suggests that the report, the draft that was sent and discussed at the think tank was approved by the PP, when in fact that was not the case. It was just discussed there but not approved. Hence it was sent back.
And you then sent the letters on to Advocate Matlawi.
That is correct.
Right? And he then forwarded those drafts. If you go to SS9, those drafts were then forwarded at 2221. You see at the bottom that in February 2017, there is an email. You see it, Advocate, Mr. Samuel?
Yes, I see it.
And it says, dear PP, from Advocate Matlawi to Advocate Mkubana, the attached are draft documents which relates to the Vrede matter as raised by Minister Zwane yesterday. Do you know what that reference is raised by Minister Zwane yesterday?
I was not party to any meeting with Minister Zwane, but I took it that this could have been a meeting that was held at head office with Minister Zwane.
These documents have been going to and fro because your predecessor felt that Free State did not address the issues that were raised with her. So at some point it was a futile exercise to submit them to her because she was expecting Free State to make specific findings, which it seems was not captured in the Section 7I notice and the draft provisional report. Further than that, these documents were not drafted in accordance with the relevant formats approved, so we would still have to send them for non-compliance. I hope this clarifies the matter to you, PP. We can still discuss the documents if we need further clarity. Does that accord with your understanding of the position at this time, Mr. Samuel?
That is correct.
Then, if we go to page 2119, para 139 of your affidavit, there is then a stakeholder consultative engagement which takes place, and the PP comes to the Free State in March of 2017. Do you recall that, Mr. Samuel?
Yes, I do.
And what was the purpose of this visit?
This was a process that had been initiated by Advocate Madonsela during a time where she would go around the country once a year to meet with the stakeholders. These were divided, the stakeholders that she wanted to meet and engage with were politicians on the one hand and members of the public. And the public protector, Advocate Mkhwebane, continued with that practice. So this This visit in March 2017 was one such visit to the Free State.
And was there any specific requests made for any particular visit she was meant to have at that stage?
No. Oh, well, there was a request made or conveyed to me, apparently made by the then Premier Advocate, Mr. Ace Mahashule. We were working with the officials from the Premier's office to arrange visit to the legislature during this roadshow, and they conveyed a message to me that I should convey to Advocate Mkhwebane.
Okay. And did you do so?
Yes, I did. The message was that the Premier wanted to meet with Advocate Mkhwebane before she goes to the legislature the following day.
And what was her response?
I remember we were in her hotel suite as part of, I was there as the representative from the Free State office who had to brief her on the process and the itinerary for the 2 days that she was there to visit. Other people that were present were the CEO at the time and people from head office. I recall that one of them was the spokesperson at the time, Ms. Khalalelo Masidi. But her reaction, to come to your question, was that she doesn't take instructions from him, she doesn't know him, and she is not going to go and meet him. And she also asked me whether I had met him. And I said no. Since I transferred to the Free State, I had made attempts to meet with him just to introduce myself, as I'd done in the Limpopo, province, as part of introducing myself to the leadership in the province, and try and to seek cooperation with our investigations.
What then transpired, Mr. Samuel?
A few minutes, we went on with the briefing, and a few minutes later, she received a call. I don't know who had called her, but she then walked to the one end of the room and took the call. And on her return, she said she had changed her mind and said she would go ahead and meet the Premier, and that she would introduce me and the then CEO to the Premier. So she then instructed that we should meet her the following day at 7 in the morning or 7:30, I can't remember correctly, but to meet her at the Premier's office. And we left it at that. We agreed. I then arranged with the then CEO to pick him up at his hotel the following day to go to the Premier's office as instructed. On our arrival the following day at the Premier's office, Advocate Mkhwebane and her security and the driver were already there. We were then ushered in to go to the 4th floor, which is where the Premier's office was located. On our arrival on the 4th floor, the Premier's PA was already waiting for us, and she ushered Advocate Mkhwebane, to the Premier's office, and myself and the CEO, we were ushered to the waiting room.
And then what happened?
She had that meeting with the Premier, and I think it must have lasted about 15 to 20 minutes. And then she came out and went, I think the Premier escorted her to the lift and she left. Thereafter, the Premier came to the waiting room and introduced himself to the CEO. And thereafter just turned and walked away. He didn't interact with me at all.
Did he acknowledge you at all?
Not at all.
And you actually don't know what the conversation was that ensued between the Premier and the Public Protector?
No, I don't know.
And did she tell you anything?
No, she did not.
And anything that you could only speculate as to what it's about? You have no personal knowledge as to that conversation?
I do not. I do not have personal.
And did she relay any information to you after this meeting about the Vrede matter?
No, she did not. But sometime later, she indicated that she had made some undertakings to release that report and started following up on the Vrede dairy matter.
And what was the nature of those undertakings?
The nature of the undertakings.
Yes.
It was that she had made an undertaking to release the report and that it would be ready by the end of April. I then assumed that this undertaking must have been made or might have been made during her meeting with the Premier.
But she didn't say anything to you coming out of the meeting?
Yes, no, she didn't.
And if you go to SS10, which is on page 2223, there is an email dated 27th March 2017, where the PP says, I made a commitment that the following reports will be ready end of April by Free State PPSA. 1, Vrede Dairy, and she says, I want to visit before we finalize the report. Let's issue the 7-9. 2, Placela, 3, Taxi Rank, and 4, website. Were those 4 reports outstanding at the Free State?
That is correct, but the only reports, all the reports were being handled by the Free State, except the website, which was done at head office.
Okay. But it related to the Free State?
That is correct.
And then if one looks further on that page, there is then an endeavor for her to get a date together to come and visit the Vrede Dairy project, correct?
That is correct.
Right. Right. You then, if one looks at page 2121 of your affidavit, you say that the Advocate Matlawi then sent the draft from the Provincial Investigation Unit at head office, together with the section 7-9 correspondence to be reformatted. That is the same documentation that is annexed as SS9, correct?
That is correct, Chair.
And attached to Advocate Matlawi's correspondence was another draft of the report. You refer to that at paragraph 141 of your affidavit. You see that, Mr. Samuel?
Yes.
Mr. Samuel, for the purposes of the record, you must answer so that the,
I thought the question was still following. My
sorry.
apologies.
and did you get this draft, Mr. Samuel?
Yes, I did.
And what was the difference between this draft and the one that Advocate Cilliers had circulated earlier?
It was the same, with a few peculiar changes.
And you deal with that at 141, at 2122. And what were those changes that you're referring to?
The public protector was referred to as TN Matonsela instead of Busisiwe Mkhwebane. And it also reflected that the public protector had been assisted by Erika Cilliers and Tsiamo Muchumi rather than the Free State Provincial Office.
And why do you describe that as being peculiar?
It was peculiar because the public protector at the time was now Advocate Mkhwebane, firstly. And the directive that she had given subsequent to her taking over, as, to her appointment as the public protector, was that reference should not be made to individual investigators that had assisted in the drafting of the report. It must instead reflect the originating office. Hence, it should have said Free State Provincial Office.
And were the names reflected, which you see at 2241? Were the names that were reflected, were they investigators at the Free State Office?
That is correct. Erika Cilliers was a senior investigator and Tsiamo Muchumi was the investigator in 10 at the time.
And when this document was sent on the 27th of March, 2017, were they still both there?
No, only Advocate Cilliers was still there. Tsiamo Muchumi resigned in April 2015, a month after I transferred to the Free State.
So do you know how this change came about, putting the name back?
I don't know who, how the changes came about. Yeah.
And did this draft reflect the changes that Advocate Matonsela had wanted to implement?
No, it did not.
And in every other respect, was this draft the same as the one Advocate Cilliers had sent previously?
That is correct.
You then, if you go to SS12 at 2242,
Yes, I'm there.
right? You then sent an email, and what's attached to this email?
It was the Section 79 letters in respect of the Vrede during investigation.
And it also says in the attachments formal report, Friday 13 March 2017,
That is correct.
right? And so the report was also attached to it. Right?
That's
And
correct.
you then say there is a scheduled visit by PP and team of the farm on the 10th of April 2017, and I hope our observations will not affect the report and letters as they stand. What did you mean by that?
I cannot quite recall what the issues were, but because the investigation was still incomplete, I might have been referring to issues that the public protector might want to be included or might not want to be included in the report. For us, it was still a draft, which had not incorporated the concerns of the previous public protector.
Okay. And this draft report, that you sent is attached to your affidavit marked SS13, and it starts at page 2243 of the affidavit.
Yes, that's correct.
If one looks at it, these comments on the right-hand margin, are those formatting changes?
That is correct.
Right. And if you look at the heading on the top of page 2244, the date has now changed. It's no longer November 2014. Isn't that so?
That is correct.
It now says March 2017.
That's correct.
Right. And what was the changes effectively on this report that you can recall?
The changes related mainly to the structure and the format of the reports as required by Advocate Enquiry. She required that report or the draft, presumably in preparation for a visit to the Circulated dairy farm, which was to take place in April.
Okay. And and had the investigation at that stage been completed as yet?
No, it was not.
What still needed to go into the report?
The role of the politicians still needed to be considered. I had made attempts to engage with the premier. The politicians that were referred that were relevant to this investigation were Premier Ace Magashule and MEC at the time, Mosebenzi Zwane. So I had made attempts to get to interview them, and they had not cooperated.
And what else did you do? If you look at paragraph 145 of your affidavit, you describe certain steps that you had taken on page 2123. Can you tell us what those steps were?
The steps I took were to consider the only relevant information available to us at the time, which was the information from the legislature's Hansard, some public speeches and speeches that both Mr. Magashule and Mr. Mosebenzi Zwane had made in the legislature and in the public. There was also evidence that we had received from officials employed in the Provincial Department of Agriculture, including the head of department. But the other officials were not willing to come forward. They feared reprisals. I also took into account the information or the evidence that was collected by Advocate Cilliers. And at the time that we went for the inspection at Friede, I requested the public protector, requested permission to her, from her to that we should issue a subpoena against the politicians because they were not cooperating with us.
In which way were they not cooperating?
They were not responding at all to our advances to either meet or provide information regarding Friede.
And as provincial representative, could you issue the subpoena against politicians?
No. The directive was that any subpoena against politicians at whatever level would have to be issued by the public protector, but against officials, including the HODs or DGs, I have the delegation to issue those subpoenas.
Right, and so you say you then had a site inspection at the Friede Dairy Farm.
That is correct.
Right, and when did you make this request to the public protector to issue the subpoenas?
It was during that, on the day of the inspection, as we were being taken around the dairy farm.
And what was her response?
Her response was that she does not want any findings made against politicians. And so she declined my request to prepare the subpoenas for her signature.
And what was your view on the matter?
I accepted her, her directive at the time and knew that I could not take the matter any further. So I had to rely on what was available to me.
Right. And what did you then do? The PP on your evidence said that she didn't want any findings against politicians.
I did not persist with my request, so I then prepared a draft and made findings against, or adverse findings against both politicians to the effect that they owned up to this project and that it is impossible that the HOD could have been acting alone in whatever he had done without either direction or direct instructions from the politicians.
So if I take you to page 2261, which is an email .
Yes.
Okay, tell us about this email.
This email was sent by Advocate Cilliers to myself, in which she says, "Dear SHS, those were my, that was short for my full name, Sphelo Hamilton Samuel. We have finished the report and are starting the Section 79 letters. We are making findings of maladministration against the Premier and MEC, therefore three notices and one discretionary notice for the SIU. We took out remedial action for the Auditor General and Auditor General Free State is already busy with audit and the project. CISA and I met him and his team on Friday. Thanks, Erika.
Okay. And if you turn the page, there is a report attached. Was this the report you received from Advocate Silius?
That is correct.
And this report, if you look at 2263,
Yes.
is a report dated April 2017.
That's
Correct?
correct.
If you go to your affidavit at paragraph 150, you summarize some of the findings in the report. Can you talk to that, please?
Yes, I noted that the evidence showed that the Estina agreement was not concluded in accordance with the binding procurement framework, which constituted maladministration and the contravention of Section 217 of the Constitution, and that the rules regarding the public-private partnership which were applicable were not followed. The prices paid for the equipment, cows, and infrastructure was considerably higher than the market value. We concluded that the accounting officer was guilty of gross irregularity, maladministration, abuse of power, and improper conduct, as well as irregular expenditure. We found that amongst other things, he should not have paid over more than 143 million to Estina after the Accountant General's report, which raised significant concerns about the transaction. And furthermore, he had failed to put in place financial controls and risk management measures in respect of the project. And that in addition, there were no invoices or receipts to substantiate the expenditure claimed. Findings were also made against the Premier and the MC for their failure to institute disciplinary action against the senior officials responsible for the unlawful agreement in accordance with the Accountant General's recommendations, and that this constituted maladministration on their part. And the allegations that environmental legislation had been breached were not substantiated.
So if you go to page 2327 of annexure SS 15, you see the last sentence on paragraph 6.12. Is that the finding that the failure by the Premier and the MEC to institute disciplinary action amounts to maladministration?
Did you say 2327?
No, 2327, paragraph 6.1.2.
Oh, yes. Yes.
Okay. And then if you go back to your affidavit at para 152, what happened with this report?
This report was circulated both within the Free State and to head office. And in addition, draft section 79 correspondence was sent to head office together with the certificate of compliance in respect of the investigation.
Just explain to us, what is that certificate of compliance?
The certificate of compliance was one of the requirements introduced by Advocate Enquiry, that we had to complete from the investigator assigned to do an investigation, his or her line manager, all the way up until the report gets to, gets to her for signature. That we had to comply with, to certify that we had observed all the requirements. We had stated all the facts and the law, and that our findings, are in line with what the complaint was and remedial action, everything, including certifying that the structure is in accordance with the directives and so on.
Right. So if I take you to Annex SS 16, which is at page 2333.
Yes, I'm there.
This is the email that contains the certificate of compliance. And then it refers to the section 79 letter. Who gets a section 79 letter?
All implicated parties against whom we make adverse findings should be sent the section 79 letters. In this case, it was Premier Mahashule, the HOD of the Free State Department of Agriculture, and the MEC of Agriculture at the time, Mr. Msebenzi Zwane, and any other parties that we deemed fit to receive the report and would have to consider the remedial action. In this case, it was the SIU.
And so that you call a discretionary letter?
Yes, that is a discretionary letter as opposed to a section 79 notice, because we're not making adverse findings against them.
Now, Mr. Samuel, how did you get these emails?
In the emails relating to
Now,
these, or emails general?
no, the emails which refers to all the documentation, because you say in your report, you can't locate a copy of the email to which the report was annexed. Mr. Samuels, when you left the PP's office, did you have all these emails?
No, I did not.
So how did you get these emails?
Oh, the emails were recovered by the evidence leaders and sent to me to have a look and see if I could assist this committee when looking at those emails in relation to what I had stated in my affidavit.
And did you get a copy of the email to which the report was attached?
No, I didn't.
And was the emails that was provided to you all your emails?
No. When I was suspended, my laptop was taken. But prior to that, a day before that, I had been completely blocked from the ICT infrastructure. And so when my laptop was confiscated, that was the last time I had, an opportunity to access my emails. And not all the emails were there amongst those that were recovered by the evidence leaders. Because some of the glaring example is that between March, after the public protector's visit to the Free State on the road, during the road show, I was requested to go and manage and do an investigation in the Gauteng provincial office. none of those emails relating to my work there, and were amongst those, and there were quite a number of others that I wanted, that I had a recollection on, that were not recovered.
Okay. Now, if you turn to annexure SS 17 at page 2334, there's an email at the bottom from Advocate Matlawi, at the bottom of the page. All right. Where he says, "Dear PP, I have looked at the attached letter, specifically the one addressed to the MEC, and made appropriate comments. I'm not sure why all the letters are marked discretionary notices. In fact, the only discretionary notice should be a letter addressed to the complainant, which to me seems from the way it was drafted. The letter to the SIU should rather be a cover letter to the Section 7(9) notice addressed to the HOD. Since the SIU is not implicated, it's technically incorrect to address a 7(9) notice directly to it," and says, "I await your guidance."
Yes,
You are included in that email,
that is correct.
right? And then there's a further email sent, which one sees, if you go up on the page, on the 22nd of May, where he says, I've in fact not attached the Section 7(9) notice addressed to the HOD as I had intended. And then he attaches the documentation which says new corrected draft MEC, new corrected draft SIU, new corrected draft Premier, complaint document, and new corrected draft HOD. You see that?
Yes, I do.
And the PP is included in both emails.
That is correct.
Now, what follows in the annexures of 7, the next page of SS 18, is a request from Advocate Matlawi to the PP, asking for her to approval and signature of the Section 7(9) notices.
Yes.
And then if you turn the page to SS 19, one sees the letter that is prepared for the Premier, correct?
That is correct.
And if you turn to page 2357, at 10.1.3, can you read that?
Paragraph reads, the Accountant General's report found that the PPP was irregular and recommended that the Premier and the then MEC institute disciplinary action against the HOD and the then Chief Financial Officer, Ms. S. Lamini. The failure by the Premier and the then MEC to institute disciplinary action amounts to maladministration.
And so that last sentence, which you've now read, Mr. Samuel, I referred you earlier on to the paragraph in the April report, paragraph 6.1.2 at page 2327. If we can just go back there. Which is the end of paragraph 6.12.
Yes.
This was the Section 7(9) was issued pursuant to the April 2017 findings in the report.
That is correct.
Is that correct? And you also find the further, well, we'll get to that in a moment. And if you go to SS 20, which is on page 2363,
Yes.
that's the signed letter that goes off from the PP's office to the Premier, correct?
That is correct, Chair.
And if you look at page 2388, you see her signature on that on 7th June 2017.
That is correct.
Right? And if you go back to page 2383 of the letter,
Yes, I'm there.
you see the finding at the bottom of the failure by the Premier and the MEC to institute disciplinary action amounts to maladministration.
That is correct.
And so, Mr. Samuel, when the litigation ensued in respect of the Vrede report, where was the record and the documentation in respect of the Vrede report?
Our whole file, which contains the record, was at head office. It was sent to head office by the direction. I can't recall whether it was of the PP or the unit that was to consider the whole report. But our file was no longer with us in the Free State.
And what was your involvement in the compilation of the Rule 53 record?
None whatsoever.
Right. And what was your involvement in the preparation of affidavits for purposes of opposing the relief or putting an affidavit before court?
I had no, I did not make any contribution to that.
And so we provided you with a copy of the Rule 53 record index, correct?
That is correct.
And that index is SS 21 to your affidavit at 2389.
That is so.
And
Maybe if you can pause there, Advocate Bauer. We'll just take a tea break for 15 minutes and be back at 1:45. We'll take a break, Mr. Samuel, and everybody in the virtual will be back at 11:45. In the meantime, Timongos, there's a complaint about it's a bit cold here, so fix that. I got that. Let's pause for a break, colleagues. Thank you.
Recording stopped.
Why do you say that, Mr. Samuel?
Because relevant information was not attached to which the findings to which the Premier was supposed to respond, or the proposed findings and remedial action.
Okay. And so if you go back to 2401, on the top,
Yes.
Advocate Cilliers then resends the letters that she had sent.
Yes, that's correct.
And you then say in 159 of your affidavit that as far as you were aware, the Premier was later provided with the information he needed to answer.
That is correct.
Right. And then, did you understand that the Section 7(9) notice was sent to the Premier and the MEC for the information, as pointed out by the PP in her email, or because there was findings against them?
Because there were findings against them.
And those were the findings that you referred to earlier on, were set out in the April 2017 report.
That is correct.
Okay. You then say the Premier responded to the Section 7(9) notice, as did the MEC and the accounting officer. At 161 of your report, we are now 2129.
That is correct.
And what happens when you get responses to Section 7(9) notices? Does your investigation stop, or does it still continue?
No, the investigation continues because that would be the Section 7(9) notices or responses to the Section 7(9) would invariably shed, light that needs to be taken into account in finalizing the report, specifically around the findings and the information relied on and so on. So the report cannot be finalized unless those, the responses to the Section 7(9)s have been taken into account.
Okay. I had asked you this question, but I see I jumped the gun a bit. In paragraph 163 of your affidavit, you say that the investigation file in its entirety had been sent to head office sometime in 2017.
That is correct.
Right. And can you recall precisely when in 2017?
No, I cannot recall.
Right. And then you took some time off from work between July and September 2017, correct?
That is correct, yes.
And although you got some of the emails, you were not in the office.
Correct, yes.
And it was Advocate Cilliers who took the lead in providing head office with assistance.
Yes, correct. And as far as the Sphelo investigation is concerned, yes.
Right. So what's subsequent in your affidavit is what you've been able to reconstruct from emails that's been made available to you for the most part.
Correct, yes.
Right. You then in paragraph 166 refer to a further report that Advocate Cilliers circulates on 8 August 2017.
That is correct.
Right? And this report if one sees that SS 23-2402 is then provided to head office. More specifically, it's sent to Mr. Matlawi, and others are CC'd in on it.
Yes, that is correct.
Right? And you did not assist in this report.
No, I did not. I was still on leave, on sick leave.
Right? And so what is attached to this email is the report which you see at SS 24 at page 2403.
That is correct.
And this draft, there are no findings of maladministration or wrongdoing on the part of the Premier and the MEC, correct?
That is correct.
And do you know how it came about that these were omitted?
I do not know.
But you then in paragraph 170 at 2131, you point out in this report there are still several other findings that exist, correct?
That is correct.
And those include?
They include that the accounting officer is guilty of improper conduct, gross negligence, abuse of power, gross irregularity, and maladministration. And that the rules regarding public-private partnerships which were applicable were not followed, and that the prices for the goods and services had been inflated, and that the allegations regarding the environmental legislation had been, whether it was breached were not substantiated.
Okay. And if you go to page 2462 of this report, Mr. Samuel. The pictures of the gate, which was alleged to have cost 2.6 million, are still in the reports, correct?
That is correct.
And the milking parlor that was alleged to cost 30 million is still referred to at 5.3.16. And if you turn the report, the page, you'll see the pictures there.
That is correct. Yes.
Right. Now, if you then go to the next annexure, which is SS 25, you will see the email from Advocate Cilliers dated 21 August 2017.
Could you refer me to the, oh, all right, I've got it, yes.
Right, she says corrections made, but TT. What is your understanding of TT?
My understanding of TT was, there was a stage when you used TT to refer to the think tank, but later on when a task team was formed at head office, this TT also referred to that task team.
And there is then a further draft which is attached to this email.
That's correct, Chair.
You didn't have any involvement in this draft, did you?
No, I did not.
And you say that this draft Although it said September, it was circulated in August based on the email.
That's correct, Chair.
And did that draft have any findings against the Premier and the MEC?
No, it did not.
You then refer to what's called dashboard minutes, which is located at SS 27. Which is page 2499.
Yes, correct, I've got it.
And you refer specifically to page 2500. Which says that the final report had been submitted, await feedback from PII. You see that in the second column, number 1, second row. On page 2500, at number 1, it says EPC, which probably stands for Eric Crucilius, Vrede Dairy Project final report submitted.
That's
Await
correct,
feedback
yes.
from PII.
Yes, I see that.
And what's PII?
PII stands for Provincial Investigations and Integration. It's the unit to which all provinces report at head office.
That would be essentially Advocate Matlawi and a few other members who would be looking at the report, correct?
They were not attached to PII. PII was the unit that we reported to, but further, Advocate Matlawi would have been placed elsewhere, either in the PP's office or in another unit that did quality assurance for the PP.
So who was in charge of PII at that stage?
It's the executive managers. There were 2 of them. One was responsible for inland provinces and other one for coastal provinces. The one that we reported to was Advocate Reginald Ndo.
Okay.
Was in charge of the inland provinces.
And then you say that Mr. Ndau then submitted the report to Mr. Nemasisi. Who is Mr. Nemasisi?
Mr. Nemasisi was the senior manager for legal services at the time.
And he then sent the report back to Mr. Ndau with changes and comments.
That is correct.
And you see that from SS 28 on page 2503.
That's correct, Chair.
Right? And if you look at page 2512 specifically,
Yes, I'm there.
right? You make reference to a comment that is attributed, sorry, I might have the wrong comment column, just give me a sec.
It's now bigger. Can you see it? Okay, Kevin. Thank you.
comment, I may have the wrong comment, but in your affidavit, you've, I'll find the correct comment, but the one I was referring to is the one in section 174(1) of your affidavit where you say Mr. Nemasisi comments, notes that if Treasury, which is not that one, my apologies, if Treasury issued a report on this with a recommendation, maybe we can ensure enforcement of such recommendations in the form of remedial action. You see that?
Yes, I see that.
And Advocate Cilliers' response, you've detailed as saying that the remedial action requiring the Premier to ensure the implementation of the findings and the recommendations by the Accountant General should be removed.
That's correct.
Let me just
If I may assist, the comment that the comment that you're looking for is on 2507.
2507. My apologies. I had it down as 25. Oh, thank you, Mr. Samuel. You know this better than me. You see that on that, right? And you say that on 174.3, and later on in the comments, Ms. Cilliers says that the remedial action requiring the Premier to ensure the implementations should be removed.
That's correct.
And that we see at and you then conclude, having looked at this, that in 174.3, that otherwise the findings of the September report is largely the same as those in the July report. Correct?
That is correct, Chair.
You had no part to play in this report.
None whatsoever.
And then Advocate Doe submitted this to the PP.
That's correct.
Right? And if you go to SS 29, which you see at page 2525, the public protector sends it back to Messias and Doe and Nemasisi.
Correct, Chair.
And there's a specific request whether they can verify whether indeed this response captures the issues that was raised by the Premier.
That is correct.
You then included in this chain because Mr. Doe seeks the section 7(9) notice that was sent to the Premier, correct?
That is correct, Chair.
Right. Right. Now, Mr. Salmon, in the next couple of paragraphs, you refer us to a revised report. Tell us about that. We're at 177 of your affidavit on page 2133.
Yes, I'm there. That revised report had not been limited to the politicians only failing to take disciplinary action. My mind, they were implicated in the transactions because they had taken ownership of the project in public. And I was satisfied that there was no way that the accounting officer could not have been acting alone. Instead, he must have been acting under political direction from the Premier and the MEC. I accordingly concluded that those political office bearers were culpable in the accounting officer's maladministration, negligence, and misconduct.
And so what did you do, Mr. Samuel?
I prepared a revised report reflecting my conclusions that I've just referred to, making findings against Mr. Mahashule and Mr. Zwane that they should be held liable, not only for failing to discipline the accounting officer, but because they had overall responsibility for the project, the manner in which it had been implemented and the extent to which it had failed the beneficiaries. I submitted that report to the head office, specifically to Mr. Ndo, as far as I can recall. In that report, I basically disobeyed the directive from the public protector that we should not make findings against the politicians. I felt strongly that they were responsible for the, for the project, and that findings have to be made against them. And I based those on the evidence that we had discovered, as I said earlier on, from a number of sources. And the unfortunate thing is that when my emails were recovered, we could not trace, we could not find this email, and under cover of which I would have sent that report.
And who would you have provided that report to, Mr. Samuel?
I would have addressed it or sent it to Mr. Ndo, to my line manager.
And what do you think happened to that report?
I have no idea. Without the benefit of verifying from my emails, I can only speculate that it was specifically excluded, or those findings were removed from that report.
And to who do you recall sending that report?
My recollection is that I sent it to Mr. Ndo.
And can you recall more or less when you sent it?
No, I cannot recall.
When you returned to office in September 2017, did you have any further involvement in the Vrede Dairy project?
No, I did not.
So did you have, you were not involved in finalizing the report in February 2018?
No, not at all.
And the changes that was made to that report were not discussed with you in any way?
No.
And you note in paragraph 183, the findings in the final report that departed from the earlier conclusions that had been reached.
That is correct, sir.
Okay. And can you detail that for the committee?
Specifically, the complaint had alleged that the processing equipment, the cows, and construction and administration services had been procured at inflated prices. that the department had indicated that it had spent 6.2 million on cows, 2.6 on the security gate and the guardhouse, and 30 million on the milking parlor. We had concluded that the prices of the milking equipment, the cows and the gate and guardhouse had been considerably higher than the prevailing market prices. And these conclusions were based on the evidence we received from the independent sources involved in the industry, specifically the South African Holstein Breeders Association. That, for instance, they indicated that only 3.3 should have been spent on the cows and 7.2 on the milking parlor. And our own inspection of the simple infrastructure comprising the security gate and the guardhouse revealed that the structure should not have cost more than 50,000 rands, as opposed to the 2.6 million that was allegedly paid for that guardhouse.
Those were the pictures you had included in the report that has been removed.
That is correct. That those were the pictures that we included. That we were also satisfied that there was sufficient reliable evidence to make findings on the other items that were alleged by the complainant to have been overcharged. But the PP concluded that a finding could not be made due to the fact that there was no procurement process followed and the public protector could not test the markets to determine the market values of goods and services procured without the necessary documents which prove the actual price for the goods and services procured. And this was in complete ignorance of the independent information acquired from the Breeders Association, which rendered it unnecessary for the office to take further steps to test the market. I have no idea why this information was ignored. Furthermore, determining the value of the security gate and the guardhouse did not require specialist input. It was basic construction of a rudimentary structure, and the April 2017 report included the pictures that we had attached to the report, which are reflected in page 2137 of my affidavit.
And that's the structure that they attributed the cost of 2.6 million to.
That is correct.
So these are the photographs, or some of the photographs that you say were included in earlier reports that was removed from the final version.
That is correct.
Then in paragraph 184 of your affidavit, you refer to the final report stating that there was an inability to investigate certain issues due to capacity and financial constraints. What do you know about that?
I do not agree. I did not agree then, and I do not agree now. I was of the view that the investigation was not hampered by any capacity or financial constraints. We were perfectly capable of determining some of these issues. As I said, we consulted some experts, which was done for free. So there was no need or issue about finances, to be dispensed in obtaining that information. And that information was included in the April 2017 reports and a number of other versions of the report. And we conclude, therefore, I conclude that the external forensic investigator was not required because we could scrutinize the financial records sufficiently. And prior to this, I had not been told, I was never informed that the public protector required additional external forensic expertise.
Now, let's deal with the issue of beneficiaries, because the final report records that the beneficiaries who were intended to benefit from the project could not be investigated due to a lack of information.
Yes.
Were you able to track down the beneficiaries?
Yes, we were.
And would it have been a tremendous exercise to do that?
No, not at all. We were in contact with the beneficiaries through their leader, who subsequently died, was killed. And we had the list of the beneficiaries. We even, when we went for the inspection, inquired whether, from the public protector through her PA or secretary, I don't quite understand, but it's Ephraim Kabinde, whether the PP during that inspection would require the presence of the beneficiaries. And her response was that they were not required.
Okay. And that response you see at 2529 at annexure SS30, where it was indicated that there was no need to invite the complainant and the delegation beneficiaries to the inspection, correct?
That is correct.
Right. Now, do you think the input of the beneficiaries would have added anything additional to the report? You deal with that at 187.4.
No, I do not think they would have added any value to it.
Why do you say that?
The nature of the complaint, they would not have shed light on the nature of the complaint itself. They were just the beneficiaries. To that extent, we agreed, although perhaps maybe for different reasons with the public protector, that there was no need for the beneficiaries to be present at the inspection. They were at the tail end of the project.
And effectively, they hadn't gotten any benefits.
Yes, they have not.
So you essentially agreed with the public protector
That is correct.
The report wouldn't have added anything to the public,
That's correct.
to the report. When the report was set aside and the matter was going to be reinvestigated, who conducted that investigation?
The report, when the investigation was then done from, it was done at head office. My information is that it was done by Mr. Rodney Mataboge, with one of the chief investigators.
You were not involved in that investigation at all?
No, I was not. We were not involved at all as the Free State Office.
Is there anything else, Mr. Samuel, in respect of the Vrede investigation that you wish to add?
No, I cannot think of anything.
Now, Mr. Samuel, we sort of started in the middle of your affidavit, right? And if we could then go to what you give me a second. Just after that, because we are there, you at 214. Oh, you describe your personal circumstances since submitting the initial affidavit.
Yes, that is correct.
Right. And essentially, you had submitted an affidavit previously to the Speaker of the National Assembly, and the affidavit was deposed to on 11th February 2020.
That is correct.
That's fine. And what informed the submission of that affidavit to the Speaker of the National Assembly?
I had, prior to submitting that report, I had made inquiries about the escalating, well, about the fact that our office was getting involved more and more in litigation, and that the other programs were suffering as a result. I had made inquiries regarding, the legal fees or the litigation that we were involved in as an office, and requested information on why we were involved in that and how much money was being spent. Because from the cursory look at the reports that were submitted to the management committee, to which I sat in, there was a standing report on finances, which at the time indicated that we had budgeted 10 million for legal fees or for litigation. And by that time, we had almost doubled. It was somewhere during the middle of the month or still early of the financial year. We had almost doubled the expenditure relating to that. And another amount, I think I recall, it was around 6 million had been set aside, or had been ring-fenced to be paid within that financial year. So those were the issues, amongst others, that worried me, that necessitated that I end up approaching the Speaker with a request to do an investigation into the Office of the Public Protector and the conduct of the Public Protector.
Right. And if we go to the bottom of 189, you then say there was severe, sorry, I'm at page 2140.
Yes.
Right. You say there were severe professional consequences for you.
That is correct.
Right. So let's take it from the top. You write this letter, or you do this affidavit in February 2020, and you then say in the next paragraph that you then write to the acting CEO in March 2020.
That is correct.
And you once again raise the issue of the expenditure on legal fees and request documentation.
That is correct.
And you refer, the annexure you refer to is at page 2198. And maybe tell us, the acting CEO at that time is Miss Lusibani, right?
That is correct, Chair. Miss Yalekile Lusibane was, in fact, the Chief Financial Officer, but at the time she was the acting CEO at the time that I wrote this letter.
Okay, and you refer to an interview that the public protector had given. Tell us about that.
As I recall, it was the day before I sent this letter, but I'm subject to correction. The public protector was interviewed by Mr. Thabo Mdluli of Newsroom Africa. And the question that worried me that he had posed to the public protector regarding the expenditure on legal fees and the, you know, and you know, he asked who was responsible for the decisions regarding that expenditure, and her response was that she's not involved. It's not her decision. It is actually the accounting officer who has that. That is why I then decided to direct this letter the very following day to the acting CEO as the accounting officer.
And what information did you seek? If you turn the page.
I wanted a detailed and complete list of all matters that the Public Protector South Africa as an institution has been involved in since October 2016. Details of how much money has been spent on each of these cases in respect of legal fees up to that date, who were these legal fees paid to, and what they were for. What policy had been used to determine which case to litigate on, and what informed the decision to litigate in each case. I also inquired what the current status of each of those cases was to date, and who had instructed that such litigation be entered into, and what the budgets were for legal services and litigation since October 2016. I received an acknowledgement of this letter from the acting CEO, but I never received that information.
Okay. You then on the next day, if you go back to 2141, you addressed the letter to the public protector.
Yes, that's correct.
And what was the reason for that letter? What sparked of that letter?
I basically asked the public protector, or I requested her to resign. It was at the back of the recent judgment in which the presiding officer had been scathing about her conduct.
And did you get a response to the letter?
No, I did not.
And a copy of that letter, one sees it 2536. I don't think it's in this letter that you appeal to her to resign, correct? So 2536.
That is correct. Actually.
And then the following day, there were various charges, disciplinary charges brought against you.
I think there might have been an error in stating it like that. The charges came at a later stage. What happened the following day was that I was, when I got to the office and I tried to log in into the server, to get my emails and so on, I had been blocked. And so I made inquiries to the CEO. That is not reflected here in these paragraphs. But as to why I had been locked out, and that I considered that to be constructive dismissal. Instead, I was then served with a notice of suspension on the same day. And my laptop was taken away from me. The charges came a few days thereafter.
Okay, so what's submitted from 192 is that on 11th March 2020 he was suspended.
That is correct.
And you say one of the charges dealt with a Limpopo assault that was described in the initial affidavit. What is the date of that assault that occurred? Do you recall?
Yes, I do. It was the 14th of December, 2011.
So you were now being charged in 2020 for an assault that was alleged to have occurred in 9 years prior thereto.
That is correct.
And maybe without belaboring it, just tell the committee briefly the circumstances of what had occurred in 2011.
On the day in question, it was early in the morning, around just after 8. I was sitting in my office on the first floor of the building we were in at the time, in Polokwane, where I was the provincial representative at the time. And I then got a call from the receptionist internally to advise me that the complainant, Mr. Siabi, was at the reception and he demanded to see me. Because I was busy with the head office, I was on the line talking to one of the officials in the HR, explaining the reports that I had submitted. And the next thing, Mr. Siabi barged into my office, and he initially sat opposite, myself, but I could see he was agitated and angry. So when I finished on my call, I then told him that I can't see him on the day because I'm busy with reports. I actually suggested to him that I can see him later in the afternoon around 2 or the following day. And instead, he just stood up and accusing me of making a stupid out of him. And he came for me and grabbed me by my clothes, by the collar. I tried to push him away, to let go of me. And that is when the struggle ensued. I actually managed to push him to, just outside the door. And there was another door with a sliding door, a glass door, which, he tripped on that and we both fell because he was still holding on to me. And because of the commotion, the other officials within the office came out to investigate, and then they separated us and he, took him downstairs. I then reported the matter to the CEO immediately.
And who was the CEO at the time?
CEO was Mr. Themba Mteto.
And what did he then do?
He then instructed me to go to the police station and lay a charge, and then to prepare a written report of the incident. And on the same day, before even my report could reach him, he had dispatched a private security firm, two, a male and a female officers to come and guard us and the building at the time. And that continued for some years. I don't know, I'm told now they are no longer there, but at the time they were there to protect us, or at least to ensure our safety and so on.
And you went to the police station to lay a charge.
That is correct. I went to the police station, and on my arrival there, I found the complainant also laying a charge against me. The officer in charge of the charge office at the time, on noticing that we were there for the same or for a case or cases emanating from the same incident, then called us into his office and tried to broker some kind of an agreement that we should drop those charges against each other. The complainant refused. I was amenable to that because I was not particularly interested in laying a charge against an elderly person, which would take up most of my time going to and from court. But he refused. So both cases were then opened and sent to the senior public prosecutor for a decision. I think a day or two afterwards, we appeared at court, and the senior public prosecutor, withdrew both charges against us. He declined to prosecute basically on both cases. And that was at the time the end of the matter until later. That was in 2011. In between, nothing happened until 2017, when I had already moved to the Free State Provincial Office. I got a call from one of the investigating officers, because two ladies came from Polokwane to come and serve me, the police officials, to come and serve me with a summons to appear in court. Mr. Siabi had revived that case against me after complaining to the NDPP that the prosecutor was unwilling to see his case to finality. That's how it got to be reinstated. And I think it was finalized in the same year, 2017, where I was found guilty of common assault, sentenced to 2 months imprisonment or 2,000 rands, which was wholly suspended for 5 years. No, half of each, yes, was wholly suspended for 5 years. So I had to either serve a month of incarceration or pay the 1,000 rands. I opted to pay the 1,000 rands to secure my release, and within 14 days thereafter, I applied for leave to appeal, which is still pending. The matter sat once in the High Court in Polokwane, but because the trial record was incomplete, it was removed from the roll. But I've now been informed by my attorney that it has been completed. The reconstruction has been completed, and the matter is proceeding. I'm waiting for a date.
Okay. And that was one of the charges that you had.
That is correct. That's one of the charges that were brought against me in 2020 relating to that incident.
And there were also other charges.
There were other charges, yes.
And what did that relate to?
It related to, firstly, the affidavit or the request I had made to the Speaker to launch an investigation against the public protector and her conduct in running the office. And flowing from that affidavit, I was contacted by various media houses to confirm effectively whether I'm the author of that affidavit and the letter to the Speaker, and on the contents thereof. So I was then involved in those interviews together with the spokesperson for the public protector in the office, Mr. Sphelo. And so I was then charged with conducting those interviews, firstly, and then secondly, leaking or allegedly leaking my affidavit to the media and making disparaging remarks against the public protector. There were in total 9 charges. Also insulting the public protector, breaching the Public Protector Act and the policies of the Public Protector, in mainly the grievance policy and procedure, in that I had taken my complaint to the Speaker and not to the Public Protector. The others related, I think the other related to the breach of the confidentiality clause that I had signed. But at the end of it all, I was subjected to a disciplinary hearing, and in my absence was found guilty on 5 of those charges.
You didn't attend the disciplinary proceedings?
Yes, I did on the first day, which was in October 2020. The delay, the charges had been served on me earlier around March, but because of the hard lockdown, we could not sit. And then on the first day of the sitting of the hearing, I was there with my rep, union rep, and they led evidence from one witness, my line manager, and we could not finish. So it was then postponed to late November, spilling over to early December 2020. About 3 days before we were due to go back for that hearing, which was over 5 days, I then advised all the parties, the employer, the chairperson, and my rep, everyone, that I had been in contact with a relative who had been diagnosed positive for COVID-19. And in terms of the protocols, I had to isolate and I requested a postponement for 10 to 14 days. The chairperson wanted proof of that, and I said I would bring that proof on the date that the matter would be postponed to 10 or 14 days later. Because I was already in isolation at home, I could not go out, and he refused to grant the postponement, so the hearing continued in my absence.
Right. And you were found guilty on the charges, and you were subsequently dismissed.
That is correct, yes.
You then took the matter up to the CCMA.
Correct.
And you recently got a judgment from ruling from an arbitration award from the CCMA.
That is correct.
Right? And that came down on the 4th of July, 20.
It came in a few days before, but it was effective. It effectively said
yes.
I must report for duty on the 4th. I was reinstated that I should report for duty from the 4th of July, which I've done up until now.
And so effectively it set aside the disciplinary hearing.
That is correct, yes.
Right. Now, when the assault occurred in 2011, were there any steps taken internally by the office? Did you provide a report or anything?
I provided the report as instructed by the then CEO, and he later came back to me to say the executive committee, EXCO, had discussed the matter and found that based on my report, there was no wrongdoing on my part, and so no steps would be taken. And that was the decision at the time.
That was relayed to you?
Yes, that was relayed to me.
Mr. Chief, it's 1 o'clock and it might be a good time to, I'm in your hands.
So I am keeping quiet. You're in my hands. Thank you, Advocate Bao, for watching the time. We'll pause there, colleagues, and take a lunch break and be back at 2. Hopefully she will quickly wrap up Let's take lunch
Recording
back at
stopped.
2. Thank you very much. Thank you, Honorable Bao.
From ENCA. I just wanted to clarify, just apropos what you've just said, that you reported for duty on the 4th of July.
Yes.
I'm referring to you as a former this,
Yes.
former that. So I just wanted clarity. If you have returned to the office, what have you returned as? I presume there's another, it was your job ever, were you replaced?
Yes, I was replaced, and that is
That part of
The
the
problem
issues that
now.
you're dealing with now.
yes, because I keep reporting for work, but
There's no.
they refusing to give me my tools of trade. And only yesterday, the acting public protector told me and her team, they told me that they were going to review the house. So until I
see.
get,
So the people.
yes, they say they've got advice to appeal the award.
Appeal the award.
Yes.
But you continue to
I
do the.
continue because
even-
nothing stops me until
So
then.
now just, how would you refer to yourself? Because I'm referring to you as the former
Yes.
head of the.
No, yes, I know.
Former head of that